When you die without a will, that's called dying intestate. The law is going to write a will for you if you don't write it for yourself. And so what does that mean? That means that there's a hierarchy under the law of who takes in intestacy if you haven't left a will behind, or if you left a will and there's a defect in the will, in the way that you executed it or in the supervision of the will. A lot of people don't know the intricacies of how you properly go through an execution ceremony. The hierarchy under the law is that it would be the spouse. A lot of people assume that the spouse takes all, and that's not the case. The spouse would take 50,000 plus a half. Your children take the other remaining half. That could be children from plenty of prior relationships, whether in wedlock or out of wedlock. It could be children who are minor children, and again, then you get into the guardianship scenario where the court has a say in how that money is spent until the child is 18. And it can also go on to really distant relatives. So a lot of times you have situations where you're talking about second cousins once removed, or even third cousins. And the difficulty there, which people don't realize, is that the law requires that you chase those people down, and there's a cost to doing that, especially where we live in New York City. You have international people who come from all over, and chasing down those birth and death and marriage records in other countries may not be as simple as people might think.